Hi, everyone. So thank you for attending today. Myself and my colleague, Kim Collier, are here to speak to you about getting your skilled workers and technicians into Canada. A little brief introduction on who I am. I'm an immigration lawyer and partner here at McInnes Cooper law firm. Have dedicated my practice entirely to immigration law since, for about 15 years now. Um, Predominantly assisting skilled workers and employers with their work authorizations and permanent residency, but also assisting on other types of applications as well. Pretty much anything immigration related we can handle, even including refugee law and litigation. I'll also hand it over to my colleague now, Kim. She's going to start the presentation. She can give a little introduction on herself as well.
Thanks, Megan. Hi, everyone. My name's Kim Collier, and I'm an associate lawyer in the Moncton office of McInnes Cooper. I also practice immigration law with a focus or preference for economic and business immigration, and I'm in my third year of practice. So today we're going to be talking about getting your skilled workers and technicians into Canada. So let me just, okay, perfect. So whether you're a Canadian or a foreign company looking to hire skilled workers or to bring technicians into Canada, we're going to talk about the specific requirements to get them here. So we'll be talking about key initial considerations prior to bringing the workers here, the best immigration routes or the various immigration routes for various scenarios. And then also at the end, we'll have Meghan talk a bit about the compliance piece as well, which is obviously an important piece. And if I'm not mistaken, we'll be having another seminar focused directly on the compliance piece later this year. Okay, so key considerations. These are questions, I'll just go to the next slide, that we run through with our clients when they want to hire foreign workers. So I'll go over them quickly, but when you're trying to hire the right people, there's not really a one size fits all. So these are questions that we always discuss with our clients to make sure that hiring a foreign worker is an appropriate strategy for your business. So the first thing is how quickly do you need them? Most employers will tell us right away, of course, but the speed at which you need your workers will obviously affect whether hiring a foreign workers will meet your needs and which immigration program is the best to meet your needs. Obviously, there are current backlogs for certain programs, but as we will see, depending on where the temporary foreign worker is from and the program, there are various processing times for various immigration streams. For example, the processing time for someone from a visa requiring country in a non-essential role could take months versus there could be an immediate processing of a port of entry application for an intercompany transferee or senior executive. So from a visa exempt country. So we'll get into that as we get into the different routes, but that's a key consideration. Next is how long do you need them? So, we work with various employers. Most of the time, they want to hire the foreign worker on an indefinite long-term basis, but sometimes they just need them for a temporary time for 15 days or maybe just for a few days. So we'll get into that. But if you want to hire them on an indefinite long-term basis, you'll probably have to follow the typical process, which would include obtaining an LMIA. I will explain that in depth later, but it is a time-consuming process where you have to show that you have unsuccessfully attempted to hire a Canadian or PR, and there are strict advertising requirements. But if you just need your foreign worker for a limited amount of time to come in, for example, fix something, or to come and work, like I said, for a little bit, there are different work permit exemptions under global skills strategy, for example, which can obviously reduce time and cost. What is the position you need to fill? So the federal government has established a NOC, or a National Occupation Classification. So that details every job in Canada. So depending on the position or occupation you're trying to fill, we might be able to get you access to specialized or expedited immigration programs or processing times. For example, and I'll discuss that later as well, there's a global talent stream. So that is the advertising requirements, and the employer is exempt from advertising. So that saves us the 4 weeks up front, and that would be for certain tech positions. Other positions that are eligible for an LMI exemptions would be international trade agreements such as CUSMA, CETA. Meghan will talk about that as well. And also another great program that we'll be highlighting is the Francophone Mobilité program, which allows Francophone workers to live and work anywhere in Canada outside Quebec. And that's LMI exempt as well. Next, where are you recruiting from? So this is a pretty key consideration. Where you're recruiting from will affect the time, the process you take, and the cost. So, for example, for intercompany transferees, if you're recruiting foreign workers that already work for a foreign location of your company, there are LMIA exempt processes for these employees that are in executive roles. Another consideration is whether your workers from a visa requiring or visa exempt country. So visa requiring countries such as the Philippines, China, and India, they must apply for work permit at the Canadian Embassy in their home country. So the processing times of vary. We've seen from a couple of weeks up to several months, versus visa exempt countries such as the US, the UK, Australia, and most of Europe can apply for work permits straight at the border. You must still meet all the eligibility requirements, of course, but this can be an advantage for employers depending on where you're looking to hire. Next, where is the position located? So where in Canada are you looking to fill this position will also affect the immigration programs that are available. So we work with clients from all over Canada. One of the programs that we use often are the federal programs. So that would be the temporary foreign worker program, the startup visa, and express entry. But there are also regional programs. So specifically in Atlantic Canada, for example, we have the Atlantic Immigration Program. So that is for positions only in Atlantic Canada. Also, each Canadian province has a provincial nominee program with their own streams, eligibility criteria, and processing. Next, briefly, are you posting job ads? So whether you're advertising to fill domestically or looking internationally, as we'll get into, typically you will need to do an LMIA, which means you must advertise domestically to fill the position and meet mandatory content and mandatory requirements. So if you haven't already started advertising, this is something that we always recommend to our clients to do. And if you haven't done it already, you'll have to start from scratch. But if you already have started doing these advertisements and provided they meet the criteria for the LMIA, that will put you ahead of the process, given that minimum 4-week processing time or ad required posting time. Next, how much are you willing to be involved with the foreign worker and their family? So this is a factor that will also help us determine which program is most suitable for you. You know, some employers like to be more hands-off, and in that case, maybe the provincial nominee programs are better, for example, where they're applicant-driven and the employer doesn't need as much involvement. But the Atlantic Immigration Program, for example, is an employer-driven program where the employers must be more involved in the settlement and offering, different course and doing different courses and, being generally more involved. Do you have the administrative bench strength? So the next question, hiring and employing foreign workers really demands a lot of demands administrative time and resources. So you'll need to be prepared to manage the foreign workers, the recruitment, their files. A lot of our employers have a great, HR department that is dealing with that, but obviously the smaller employers sometimes might not have as big of as a department. But you'll need to be prepared to manage this recruiting and processing, and also depending on the program, if it's an employer-driven process, then like the AIP, you'll have to file an endorsement application, and same thing with the temporary foreign worker program. We'll have to file an LMIA for you. So those are, rigorous applications. And then even once you've hired them, as we'll get into, you are subject to ongoing immigration law compliance. So ESTC, for example, has the authority to randomly audit employers. So it's crucial that you have administrative resources in place to ensure compliance. And as we'll get into, the consequences of non-compliance can be significant. Next, how many workers are you recruiting? The number of foreign workers will also help us determine what immigration program would be best. For the provincial nominee or the AIP programs, maybe those are best if you're recruiting multiple employees because the processing fees are either free or much lower, as opposed to the LMIA, which is $1,000 per foreign worker, would have a greater cost. And also, the more temporary foreign workers you hire, the more internal resources you'll need to manage recruiting, processing, and legal compliance. And then lastly, of course, what's your budget? Hiring a foreign worker is not a free endeavor, and you have to make sure that you have the budget to cover the cost. You may be required to pay processing fees, and depending on if you're hiring a lawyer, you should expect to incur legal fees as well. Of course, if you're hiring multiple foreign workers, those fees could be reduced. So next, briefly, I kind of already touched on this, but another consideration is the country of origin. So the nationality of your temporary foreign worker is extremely important when determining how long it will take them to get a temporary resident visa. This is because those applications are actually processed overseas or at Canadian embassies. So as you can see, Mexico is a recent addition, but we also have China, India, Russia, Philippines, and most of Asia. They have to apply abroad, and the processing times can be a bit longer, as opposed to US, UK, and then several European countries, as well as Japan, South Korea, and Australia. They, once the LMA is approved, or once, or if we're applying for a work permit at the border, they can apply directly. So that would mean immediate processing, which is, obviously a lot quicker. One quick note is that the country of residency or nationality is actually not important for PR or citizenship. We're talking here about temporary resident visas, so work, study, or visitor. The processing times would be all the same. And another point, entry visa is actually what we call a TRV, which is the official language set out in the airport, the temporary resident visa, and that is required for the citizens of the visa requiring, as opposed to the visa exempt. They need an ETA, an electronic travel authorization. So that is an online application where if you're coming to Canada by plane, you will need to apply online. It takes a few minutes, and it's linked to your passport once it's approved. And the only people that are the only exception to this would be U.S. citizens. Otherwise, you will still need to apply for that ETA if you're visa exempt, or your TRV if you're visa requiring. So now I'm going to pass it over to Meghan to talk about exemptions to work permits.
Hi, everyone. So I'm going to talk about some exemptions to the work permit process. So, Kim went over a number of the questions we'll frequently ask clients when we first meet to decipher, what options are available. And one of the first things we do, as Kim, just mentioned, is, ask where is this individual, coming from, or what's their nationality, because it's significantly going to impact the processing time. If they're visa exempt, they can apply at the border for a work permit or work permit exemption. If they're visa requiring, then it's going to have to be done overseas through a Canadian embassy. It's going to take anywhere from several weeks to several months. So very important consideration. But once we figured that out as well, one of the next things we'll ask is we'll try to decipher out whether there are any work permit exemptions. Like, is there a way to get this person here without the need for a work permit at all? And so I'll talk about a couple of the ones, we're not going to discuss, as you know, immigration is very nuanced. There's many, many different, categories and streams. But we're going to talk about some of the ones we use most frequently here today. And so we're going to talk about 3 work permit exemptions that we use most frequently in the type of situation where maybe you're bringing a technician or skilled worker to Canada, in this case, on a short-term basis. So the first work permit exemption I'll discuss is just a regular business visitor. So, this includes individuals who are coming to Canada to attend, conventions, conferences, negotiations, that kind of thing, and meetings. And so the idea is that this person isn't entering the Canadian labor market. They're not taking a job from a Canadian potentially. The idea is that they're really temporary. The purpose of their business is international in scope. They're still being paid by the foreign company. They're still employed by the foreign company, and the purpose of their entry really falls under one of the general business visitor criteria. And so this would include, for example, a CEO from a multinational company coming to Canada to meet with one of their offices and other personnel in their Canadian office to discuss high level business management. You have to be careful here, though. There is a line that can be crossed, right? Once there's a situation where this person is coming in and they're not really entering for business meetings. They're actually coming. They're working on the ground with the team. Then you're kind of getting into the realm of work permit being required. And so I mention that because I see it frequently. People think, oh, well, they're just coming for meetings, but the reality is that it's not really high level business management meetings. It's more nuanced than that. They're actually coming and they're kind of doing their job here in Canada. And whether that's for a few days or a few months, it doesn't matter. Work permits required once they're deemed to be entering the Canadian labor market. So a good idea if you're not sure to get some advice on that, because I've seen it many times where, people are entering and they really should get a work permit. Next slide, Kim. So this is another work permit exemption that we use quite frequently, and it's called after sales service. So this is a situation where, if you're a Canadian company or a Canadian company has contracted with a foreign company for the provision of services or for the provision of a piece of a sale or lease of a piece of equipment. And then as part of this initial sales contract, it's agreed that there will be technicians coming over to maybe set it up, to provide training, to oversee the setup. And then this could also include warranty work as well later on down the road. That was considered at the initial contract stage. So it's clear in the initial contract that this warranty work is to be covered as well. Then in those cases, a work permit's not required. It's a very specific carved out work permit exemption, and we use it quite frequently. But it's important to know that, often just a letter kind of explaining this is not going to suffice at the border. These people are coming to work, right? They're getting paid, they're working. They qualify for a work permit exemption under a very specific criteria. So in this case, we would, include a submission letter, a copy of the contract that clearly says and outlines, that this work is to be done as part of the original sales contract, and letters from both companies, an explanation that this person is specialized. So you can imagine if this person is coming and they're from a visa exempt country like the U.S. or Europe, then they can actually apply for this at the border. So they submit the application at the border, and they're essentially either given a visitor record or they're just kind of waived in the review. Their application is reviewed and they're waived waived in. So we use this work permit exemption quite frequently. It cannot include, hands-on construction work. There are certain exemptions to this, like if it's like a really specialized piece of equipment and these people need to be, they're the only people in the world that know how to put together this, this piece of equipment or this, structure. Then there can be carved out exceptions for that, but you need to be clear in how that might work. So and how that that's the case in the application. So it is an involved application. It does require some work up front to make sure the person's prepared at the border, but we use it all the time, and it's excellent because the person does not need a work permit. They're work permit exempt. Next slide, Kim. So this is another work permit exemption that we'll use frequently. It's called a Global Skills Strategy Work Permit Exemption. Essentially, this was implemented a number of years back by the Canadian government to allow kind of, the short-term work, high-skilled short-term work, for limited duration without the need for a work permit. So an individual can, as long as they're a high skill, so this is what we consider tier 0 or 1. So Tim mentioned earlier, there's national occupation classifications for each job in Canada. So this would include like senior executives, high level management, professionals. It does not include technicians. They would fall under tier 2 or 3. And so those types of technicians do not qualify for this specific work permit exemption. They would often need an LMIA or some other type of work permit. Some other type of work permit that we'll talk about later. So, this type of work permit, an individual can come for 15 consecutive days in a 6-month period. or 30 consecutive days maximum, of course. So not beyond that. This cannot be extended. So 30 consecutive days in a 12-month period. So we would use this type of work permit exemption in a situation like maybe I discussed earlier. You have a CEO or a high level management that's coming in from Europe or the US, and they're coming over and they're not just attending business meetings. They're kind of doing a little more than that. They're meeting with the team. They're actually working. They're doing their job. They're working on projects, but they're only here for 30 days or 50 or a week or 2 weeks. And in that case, this would be an excellent option as a work permit exemption. But you need to go to the border prepared. You need to have a letter of explanation, documentation that explains how and why they meet the work permit exemption, and they have to convince an immigration officer at the border that this is the case. So another example, so we would use this type of work permit exemption in that type of scenario. Another example would be for physicians coming to Canada on a short duration to cover locums, maybe for 30 days or 2 weeks to fill gaps, for services where, they're maybe not available, particularly in, more rural areas where it's more difficult to maybe get an emergency room physician and there's people going without coverage because someone's gone, not available to work. So these types of scenarios work really well, and they're specifically designed, for this work, or those types of scenarios are what this work permit exemption was designed for. Continue, Kim. So I'm going to pass it on to Kim, and Kim's going to talk about the labor market impact assessment under the temporary foreign worker program. Just a brief introduction about how this what this program is essentially if there's no it's kind of the fallback position. Generally speaking, this is a requirement that if you want to hire a foreign worker in Canada, you need to canvass the Canadian labor market first, prove there are no Canadians or permanent residents for the job. So Kim's going to discuss the LMIA process and how that works. I've already discussed, maybe some business visitor options that are completely work permit exempt. But Kim's going to talk about the LMIA and how the temporary foreign worker program works. And after that, I'll discuss a couple of options that exist that are used frequently that are work permit options, but are LMIA exempt. So we can bypass the whole LMIA process. But before we get to that, we'll talk about the LMIA first.
Okay, thanks, Megan. So yeah, very briefly, as Megan discussed, employers will often require a labor market impact assessment from ESDC, which is Employment Social Development Canada, to hire a foreign worker. This is the default stance. As we'll see, essentially what this is you're proving to the government that no Canadians or PRs are available for a job, and that you've tried to find someone to fill it, but there's a genuine labor market gap, that the job offer is genuine, and that you have met the job offer commitments. So as you can see, I'm going to talk, there are basically two avenues. I'm going to talk about the labor market impact assessment, but then Megan will talk about no labor market impact assessment and the various key programs that we're seeing to be able to bring in temporary foreign workers. So very quickly, like I said, an LMIA is to meet temporary foreign labor needs, and you have to establish that you can't find any Canadians or PRs. And we'll go over it quickly, but in 2015, the government introduced a lot more compliance and inspections and non-compliance penalties as well. Okay, so as I said, you have to show that there's no Canadian workers available. Essentially, there are two types of LMIAs. There are the high wage and the low wage. So if you're going to pay the provincial median wage or above, you must apply for the high wage. And then if you're paying less than that, you must apply for low wage. So I've actually pulled up the minimum salary amounts. They went up a bit in the last few years. So in New Brunswick, Nova Scotia, and PI, to qualify for high wage LMIA, it's $28.80 or $28.85 for New Brunswick, and Newfoundland it's actually $31.20. So and another point I want to make is if you are hiring for less than that hourly wage, that would be a low wage LMIA. There are also there have been changes since last fall where if depending where you live, the unemployment rate is higher than 6%, they will not process the LMIA in those cities. So as it stands in Atlantic Canada, we can't do a low-wage LMIA, meaning under $31.20 in St. John's, Newfoundland, St. John, New Brunswick, or Fredericton, New Brunswick. And of course, it would vary depending on the city, and that also varies every 3 months. So just some considerations to keep in mind. Obviously, as your immigration lawyers, we would look into all that for you, but just a couple key points. And you also have to provide documentation, including corporation and tax documents, proof that you're actively engaged in a business, a job description, and the resume. And as I've discussed, there's a $1,000 processing fee, and this cannot be paid by the temporary foreign worker and has to be paid by the employer. Another point is there's also typically a transition plan that must be done in conjunction with ESDC prior to hiring a temporary foreign worker. And then we've also seen a 10-day speed of service option offered. I'm not sure, Megan, if it's if it always works, but if it's for a skilled trade and an eligible occupation, and the employer offers a wage above the median wage, we ask for that updated processing time, or that speedy processing time. In terms of advertising, you must advertise in at least 3 locations, and one must be the job bank, unless, of course, you can prove that you can't set up the job bank, and then there are exemptions, but typically the job bank, and on 3 locations, and it must be for at least 4 weeks within the past 3 months. And another point is it has to be the median wage for that occupation in the province. So you can pull that up on the job bank, type in the job you're looking to hire for, and check what the median wage is. Next, we have a couple advertising exemptions and variations to the LMIA. So as I've said, it's generally it's not a complicated process, but there are, strict criteria for advertising, and it's it's an extensive process. But there are 2 key exemptions that I want to talk about here that would allow you to either to basically bypass the advertising requirement, or to waive certain things. So one is the specialized service technician or service provider exemption. So when the temporary foreign worker will provide a proprietary, it has proprietary knowledge or has experience related to that work, and the duration of work is limited, and there's no opportunity for Canadians, you can, it's an exemption that would apply here. The applicant must, the employer must provide additional information and documentation, and you can also ask them to waive the transition plan requirement when you need the specialized service provider. So an example here would be if you had a waste treatment facility in Ontario that has a turbine that needs to be serviced. So there's a specific component of that that needs to be fixed, and an individual would have to come to Canada to service this piece of technology, and is extremely specialized to do so, and no one else can perform that work. So that would qualify. And then the other one that I've seen pretty frequently is the global talent stream. So that initially was a 2-year pilot, but it's exceptionally useful for employers. Now it's a permanent program. So this would be related to basically tech mostly. We would also see architecture, engineering managers, and essentially how it works is there is no requirement to show ads or advertising, so it allows us to bypass that 4-week minimum time, and but you still have to demonstrate, obviously, the need, but you don't need to show that advertising. So there are 2 types of categories. There's category A, where ESDC will accept a category A application from an employer that is a designated referral partner. I would say this is pretty rare. We don't see this too often. It's pretty narrow exemption, but category B, which is used most often, is basically it's a list of in-demand, highest skilled positions, and you can find that online, the global talent talent occupation list. And it's where you're looking to hire an extremely high-skilled foreign worker for certain occupations, and that you're willing to pay them a certain minimum amount of wage as well, and that can all be found online. And like I said, it's mostly tech-based. So, for example, I'm not sure if this is a real example or a fictional one, but an example would be a startup company in New Brunswick. So let's just say they want to hire 20 engineers. The company has grown very quickly, and software engineers are a designated occupation. So we could apply for an LMIA for them. Under the GTS LMIA stream. It would be much quicker processing as well. They do promise, I think it's maybe 10 days, Meghan, but again, that can vary, but they do promise to process it quicker. And then let's just say we have the LMI approved, and then depending where they're from, if they're visa exempt, we could get them to the border right away and get them to apply. But if they're from another country, we would have to wait, of course, for the work permit to come in to be approved from outside of Canada if they're visa requiring. And then there's a couple other advertising exemptions here, but I want to touch on the first two, but just know that there are also advertising exemptions for the entertainment sector, for academic researchers and professors, and also agricultural workers as well. So next, so once the LMIA is done, however we do that, if there are exemptions or not, we would apply for a work permit for the employee. So in the application, typically what we need to include is the job offer, the employment contract, the LMIA, and the LMIA number. Like I said, if they're from a visa requiring country such as India, the Philippines, the temporary foreign worker may file their application online. But if they're from a visa exempt country, they can actually apply directly. They can come to Canada and apply directly at a port of entry. So processing times can really vary. Like I said, it really does depend on where they're located, and again, that's where the advantage of having some visa exempt candidates can help. But the processing times, some of them are relatively short, even from visa requiring countries. So next, I'm going to pass it back to Meghan. So I've talked about kind of the LMIA and a couple exemptions to advertising and things like that, but how it's the general position that employers have to go through that. But Meghan's going to really take you through exceptions to process and kind of different ways to kind of shorten things up if you're looking to hire temporary foreign workers.
Next slide. Thanks, Kim. And okay, so yeah, so the something to, I guess, to remember is, when we look at a case and we're meeting with a client to determine what options are available, the first thing I'll look at is whether there's an exemption entirely, which we discussed earlier, right? Is there a work permit exemption, and also are they visa requiring or visa exempt, because that's going to determine how long it's going to take to get them here. For a lot of these skilled technicians coming in overseas or from the US, a lot of the time they're visa exempt and can apply at the border for either an exemption or either an exemption for a work permit or a work permit that is exempt from the LMIA. And so the first thing I'll look at is obviously what country they're from, and whether there's a work permit exemption entirely, like a business visitor option after sales service. But then we want to avoid the LMIA whenever possible, because it's time consuming, it's expensive, it requires advertising. Sometimes it's unavoidable, and that's just the reality of the situation. But often, especially in a context where we're bringing over skilled technicians or professionals, often there is an exemption to the LMIA process. And so I'm going to talk about some of the most common ones we use here today, because again, we want to avoid the LMIA when and where possible. Some of the things, so these are some of the exemptions to the LMIA process. Or work permits are exempt to the LMIA, and you can just apply direct, either at the Canadian Embassy or at the border for a work permit. So we're going to talk about a couple of them now. Next slide, Kim. So, international treaties, you can go on to the next slide. There are lots of international treaties with Canada. These are just some of them that we use frequently. There are more than this. Another one we use that's not listed here is there's a Canadian free trade agreement with uh, Asia essentially. So it includes countries like Australia and Japan. So that's another one that specifically includes technicians on their list. So, that's another reason why looking at, what the nationality of the person is so important. So are they visa exempt, but also, are they from a country that has a free trade agreement with Canada? And if they're a technician or a skilled professional like an engineer, then is there an option to bring them in under one of the free trade agreements? And often there is. If they're from Europe, there's CETA. If they're from the US, there's USMCA. I mentioned Chile and Peru. There's Australia, Japan. So there's a lot of them out there. So it's something that we will look at closely to see whether there's a way to bring them in. I could spend all day here talking about the different FTAs and the different categories that are underneath. So I'm not going to do that. But what I will mention is that the two categories that we use most frequently within these free trade agreements are professionals and intercompany transferees. And so I have a couple of slides on each of these. You can change the slide there, Kim. Thanks. So intercompany transfers, this is one we use a lot. So I keep going back to this kind of example that I mentioned earlier with, we have a multinational company and there's a high level CEO or senior management and they're coming over. It's maybe not just for business meetings. They're coming over, they're actually going to be working with the team and they might come for a week here or there. They may come ad hoc. They may actually come and want to stay permanently, for a year, whatever the case may be. An intra-company transfer is an excellent option. And intercompany transferees, if it's an established company, multinational, virtually any country in the world has a GATS agreement with Canada, so a General Agreement on Trade and Services, which has an ICT category. So basically, almost any country, I haven't come across a country yet that doesn't have an ICT option. I'm sure they exist, but we haven't come across one yet. So the ICTs are ones we use really, really frequently. And essentially, there's a category for senior management or executive, and there's also a category for specialized knowledge personnel. So you can't just bring over like a mid-level engineer. That's not going to work. You'd have to hire a Canadian to do that type of job. But if it's someone that's super specialized, maybe named on a patent or was part of a patent, who's coming over and their skilled expertise is needed in Canada for whatever reason, for whatever duration, even if it's just for a few days, honestly, and it's more than meetings, a work permit's required and an ICT is a great option. This person has to have been working within the group of companies for at least a year. And they have to be coming to Canada to do substantially the same job that they were doing, before. It can be slightly different, but substantially the same job is important. Continue. We'll talk about professionals. So professionals is another really good option. So the professionals can include, and it depends on the FTA. It depends on the country. So the country that has the FTA with Canada, different countries and different FTAs have different lists of professionals. USMCA is by far the most, at least the way it is now. That could be changed next year when it's renegotiated. But as of right now, at least it's the most forgiving. It's the most broad. So it includes like technicians, engineers. There's a list of 52 professions. Actually, it even includes some healthcare professionals. It also includes like surveyors. So you see this type of work often in the oil and gas industry and construction and that kind of thing as well. So it really includes a lot of different occupations. But the one we probably see most often are technicians, engineer technicians, or just straight up technicians, and also engineers and engineer type roles. But again, there are all kinds of different professions that might qualify under the FTA, and it really depends on the country and the specific FTA of Canada. These individuals have to have, and again, every FTA has slightly different nuances, but these individuals have to have some experience. Obviously, they have to be coming to Canada, either coming to work. Depending on the FTA, there may be a requirement that they're an independent professional, or that they're coming to work on an employment basis, or that they're coming to work as a contractual service supplier. So a perfect example would be, let's say we have a Canadian company that has contracted with a foreign company for services, engineering services would be a perfect example. And so these individuals they have to send over a team of individuals to come to the Canadian premise, work with their team, give advice. Sometimes it's in a and management professional or management consultant professional is another one that we use frequently. And so they're coming to Canada, typically on a short-term basis, to provide advice and to work. And it's a contractual service supplier arrangement, right? Where they're not actually employees of the Canadian company, they're employees of the foreign company, but they're coming over to provide services or advice or work on a contractual basis. And so that would be a perfect example of where we would use, especially if they're coming from Europe or the or the US, we'd use CETA, the Canadian European Trade Agreement, or we'd use the USMCA if they're American or Mexican. So, these are used quite frequently. There are often lots of options under FTAs, and it's just a matter of getting good advice and looking through, evaluating what options are available and whether we can make it work. Next slide, Kim. So this is another one we use quite frequently. So this is not an FTA. This is a carved out specific work permit exemption. Work permit that's exempt from an LMIA. So it's an actual work permit. And so remember earlier we spoke about after sales service personnel who are actually exempt from the work permit altogether. That includes warranty work, right? So those would be covered under the work permit exemption. But often we see scenarios where people are coming to maybe service equipment that's no longer covered under warranty, or they're coming over to provide maintenance on equipment to prevent disruption. So let's say we have a utilities company. There's a situation where there's a piece of equipment, the original manufacturer is not in Canada. There's no Canadian presence in Canada. They need to contract with a European or American company to come over and service the equipment to either prevent disruption, or maybe it's an emergency situation, and people are going to go without power until we get somebody here. So there's no time to do an LMIA. It wouldn't be realistic to do that. So in those types of scenarios, there's actually work permits carved out that are exempt from LMIA. We use them frequently, and it's great because if they're visa exempt, which they often are, if they're from Europe or the US, I use those situations, those jurisdictions, because that's where we see them come from most frequently. You're more likely to see a technician come from Europe than somewhere like India, right? It's more likely that you're going to be contracting with European companies or with American companies. But if that's the situation, they're visa exempt, then they can literally, no LMIA, no visa required. They apply for this work permit on the way into Canada. We can have them here often in a matter of days or less in some cases. So it's a really great option for urgent situations. We use it all the time. And there's kind of two separate carved out options under this category. This for emergency repair personnel. So it's an emergency situation, like people going without power, maybe, for example, or where it's a situation where there's an out of warranty. So they would have qualified under the after sales service, but it's no longer covered under warranty. So there's a specific, but it's maybe not an urgent situation, but it's a situation where there may be loss of productivity, there may be people disruptions, things like that, if it's not serviced and this doesn't happen in a timely fashion. And so in those types of scenarios, you can get a work permit as well that's exempt from the LMIA. Of important to note too is that there are scenarios we've seen it where maybe we do need to send technicians from Brazil or China or India, which are all visa requiring countries. Well, these work permit options are available to them as well without the need for an LMIA, but we have to file the work permit online through the Canadian embassy responsible for their country of residence. And so processing times, as Kim mentioned, are very unpredictable, but they do range anywhere from realistically a month to 6+ months, depending on the country. So, it's if you're contracting with a company and they say they're going to send a technician from India, it's not a bad idea to maybe ask, can you send a technician from Europe instead? Because it's going to be a lot faster and a lot more predictable in terms of timeline and when you can get them here. Kim, next slide. Okay, so Kim's going to talk about this one because Kim is actually bilingual herself and lives in Moncton and deals with this type of application all the time. So I'll let Kim speak to this one. But this is another work permit that is exempt from an LMIA. So I'll let Kim speak to it a little bit.
Thanks, Megan. Yeah, so I did want to highlight this because it is really an excellent work permit that is maybe less well known, but we are using it more and more. So essentially, what this is a work permit for a French-speaking person who can demonstrate at least CLB 5. So that would be like conversational French, either by through a French test or having gone to school in French. So they can work in any occupation from tier 0 to 5 except in agriculture, low skilled agriculture work. And they can work anywhere in Canada outside of Quebec. And French does not need to be the language of work. So if you're interested in candidates from either traditionally French speaking countries, France, Morocco, certain places in Africa, or if they have conversational French, this is really a great option to get them in pretty quickly. So again, if they're visa exempt, we could get them to do a port of entry package. If they're visa requiring, they'd have to apply online. But essentially, you'd have to issue an offer of employment, and we'd have to get that all signed up. But they can basically work very flexibly anywhere in the country except Quebec and in any role at all, except low skilled agricultural, as long as they can prove French. So I just want to highlight that as an excellent option, and that's why when we interview potential employees, we always ask them whether they have that as well, because it's becoming more and more of a strategic advantage on the work permit side, and then down the road also for PR, it would also be a significant advantage for that employee too.
Yeah, thanks, Kim. And just to add on, sorry, you were done? Yeah, you're on mute. So just to add to that, we often will, giving advice to clients will often, recommend, if you are recruiting, you're actively recruiting, particularly in a low skilled or low wage occupation. It's not a bad idea to recruit in French speaking countries, even if they're visa requiring countries, because you can completely bypass the LMIA process. And the reason for this exemption or this type of work permit is the Canadian government are trying to increase French speaking populations outside the country or the province of Quebec. And so it's a real initiative for the Canadian government. It's not going anywhere anytime soon. And so a really great opportunity. And these people have really good opportunity for PR right now as well, especially in a climate where PR's options are limited for many individuals. So highly recommended as an excellent option. Not just for your low wage, low skilled workers, but also for your high skilled, even technicians. Like even if you have a situation where we have like Europeans, a lot of them speak French. A lot of them have a mid level, French abilities. I lived in Europe, and most people speak multiple languages and are better at French than I am. And I did French immersion growing up. It's because everybody speaks multiple languages there, and so it's always worth asking the question if you're interviewing too, and they're not from Canada, is do you speak French? Because they don't need to be from France or from a French speaking country. They just need to be able to speak French. And so this option works as well, even for your technicians that you're bringing from abroad. If they're coming on a short-term or a long-term basis. So it's an excellent option, particularly right now in a climate where we have limited options for permanent residency, but also limited options for LMIAs. And Kim had mentioned earlier that the government are refusing to process LMIAs in jurisdictions where there's an unemployment rate of 6% or higher, which includes where I'm located, St. John's, and as well as other locations and cities in it all across Canada, particularly in Atlantic Canada. It's something to keep in mind and to use in your back as keep in mind and use in your back pocket, because it's definitely something we're seeing used more and more, and there historically it hasn't been used enough, honestly, and I think we're going to see a massive uptick in this type of application in the coming weeks and months because of the inability to be able to get work permits in some jurisdictions for lower wage. Like I think it's less than 30. I think you said $31 an hour. Kim, was the medium wage. In Newfoundland.
Newfoundland, yeah.
Yeah, Newfoundland, but it's like high 20s in other provinces and territories. So. The other thing I'll mention too, actually, before we get on to, I think we're going to compliance next, we're almost done, is there is another work permit as well. We don't have a slide on it, but I will mention it. It's called a significant benefit work permit, or we call C10. work permit. It's essentially another type of work permit similar to the Francophone mobility or the ICT or the professional work permits. It's similar in that there's no LMI required, but it's a carved out specific LMIA exempt work permit that's meant for situations where there would be a significant benefit to Canadians generally, or Canadian society as a whole, by allowing or bringing this person into Canada, such that it negates maybe the need to have to advertise or canvass the Canadian labor market first, or it's an urgent situation it wouldn't be feasible, realistic to advertise or to get an LMIA first. And so it's a discretionary application. So the immigration officer at the border or overseas, if they're or the Canadian embassy reviewing this, has to make a decision, as a subjective decision essentially, as to whether they think there's a significant benefit here. But we use it a lot, and we use it quite frequently at the border and otherwise, particularly at the border, just because most people we tend to bring in are from visa exempt countries. Some of the situations we've been able to use this for are, physicians. I keep bringing up physicians, but physicians, particularly where there's like an urgent need. Maybe they need to come for longer than 30 days. So that work permit exemption for them I discussed earlier maybe doesn't really work for them. They need to stay longer, or they need to come, multiple times over the course of the year. So that's a good option. But and maybe in a situation where it's urgent, so there's no time to get an LMIA. Maybe it's a rural area, that kind of thing. That would be one case. Another would be like if it's like a large energy project and this person has really specific, unique experience, and for whatever reason they don't qualify under any of the other or LMIA or work permit exempt categories. So they need a work permit, but LMIA is the only option. But this person's really important. The expertise is very unique. Obviously the large energy project or construction project or whatever it is going to have a significant impact on other workers in Canada, Canada, the economics of Canada as a whole, whatever the case may be. So as long as we can make the case, and typically we can, especially if it's like a large project that's been in the news or something like that, then we're typically able to make that case. If it's like a mid-level technician, maybe not, but if it's kind of like a more senior personnel or a more specialized individual, then we certainly can. So it's just something to make note of, as well as that if it's a situation like that, there's almost always a way to bring them in and bring them in quickly. But everything would, but part of what we would do is evaluate whether that's a good option, whether it's feasible, and what the likelihood of success would be to get an approval. Next slide. So I'm going to just speak really briefly on compliance. Kim mentioned earlier that we're actually, I think some of our colleagues are actually doing a full presentation on compliance later on this year. And I encourage you all to attend if you're hiring foreign workers, because I think this is a area where people really do need advice, and where if you're not getting representation, and even if you are, in some cases, it's really easy to make mistakes and to find yourself non-compliant. So one of the things I'll mention is, it's your obligation as an employer, but also the foreign worker, both of your obligations, to ensure that you're both in line with your compliance obligations under the law and under the work permit. Okay. So if you're applying for any of these types of work permits that we've discussed today, they're all employer specific work permits, which means that your name as your company, as the employer, will be listed on the work permit and will be listed on that either the LMIA or the online application, or the online portion of the application that you would have filled out as part of this application. And so whatever you put in there is really important that you abide by that throughout the duration of the person's employment while they're on a work permit. So if they're, if they get a raise, or they move locations, or they, are given a bonus that maybe wasn't discussed at the outset, none of that is actually permitted. It has to be outlined at the initial, stage of the application. We often will see scenarios where there's situations where there's, in some cases, minimal non-compliance, but non-compliance nonetheless. And honestly and frankly, in many cases, we do see quite significant non-compliance from on the side of the employer without the intention. Next note, Kim. So, just this is a kind of a complicated slide, but this basically just outlines, what the consequences are on both the employer side and on the foreign worker side if there's non-compliance. And so on the foreign worker side, you're looking at inability to be able to apply for permanent residency, refusals of work permits, removal proceedings potentially if it's found out that they're working illegally. Because if you said that they're going to work in St. John's, Newfoundland, but then they moved out to Corner Brook, Newfoundland, and now they're working there, that's illegal work, even though you're still named on the work permit. So like that kind of thing happens, and it can have some pretty serious consequences for both you and the foreign worker. On the employer side, about a quarter or so of employers get audited. So the chances are, if you're hiring foreign workers, the chances are pretty high that at some point you will get audited. And it's important that you respond when you're truthful and that you're honest, because transparency, even if you are non-compliant, is something that will allow them to give penalize you accordingly. Okay, so and the penalties can range anywhere from a warning, which is often what we'll see for kind of the less egregious type of scenarios. It can trigger future audits as well. So make sure that you're fixing things. If and this is why we say at the beginning, like administrative bench is so important. If you're going to be hiring foreign workers, you need to make sure that you have someone who's dedicated to this and that who understands it and who's able to ensure that that you're being compliant. But it ranges from anywhere from a warning to fines as low as $1,000 to several $100,000. And in really egregious circumstances, there can even be jail time and criminal offense. So I'll just have Kim go to the next slide. This is the employers who are actually non-compliant are actually listed on the IRCC website. Well, this is Service Canada website. This a name shame. It's no, nobody wants to have their name here, but you'll see here, like it shows the penalty, it shows the section of the act under which they were non-compliant. And it has their name, business name, their address. So, this is a pretty long list. You'll see there's 83 entries. So it's something that, employers do have to deal with. It could mean blacklist from the program or, for a certain period of time. Or it could just, like I said, be a fine, or it could be, like I said, a warning. And then just to leave it on a little bit of a scary note. I'm sure none of you are doing this, but there are scenarios where there have been some pretty serious non-compliance where there's a lot of abuse of foreign workers. There's people working illegally. There's abuse in the sense that they're not treating the employers fairly, maybe not even paying them or paying them a lot less than they said they would, holding their immigration status over their heads, things like that. And those types of scenarios, you really see, the government coming down hard on them. This was a situation or a case not too long ago. I think it was just last year. It was a lobster plant in New Brunswick. They were fined quite a heavy fine, and they were found to be, egregiously non-compliant. And then there was another case a number of years ago. If you go to the next slide, Kim, this was in Edmonton, and there was an individual who was employing, I think this was a construction project, and there were a number of foreign workers without proper documentation, and this person was actually sent to prison for the failure to respect the compliance obligations. And that's it. So this is just a slide on MC training. We do offer MC training. So, if you or your organization are interested in, we offer advice as well on an hourly basis, of course, but if you or your organization are interested in maybe getting some training internally on compliance, maybe you have that administrative team that needs to understand compliance a little bit better, and want to do maybe an internal audit to kind of fix things, or maybe you are, interested in learning a little bit more about that Atlantic Immigration Program or LMIAs, or whatever it is you may need, then we do offer training, and it's a new service that we're offering. So if you're interested, feel free to reach out. We'd be happy to provide you with further information. All right. So I don't know if we're going to go through the questions. So I guess I have a couple of questions in the chat. We do have a little bit of time. What I'll do is, I guess I'll go through some of the questions. Certainly want to be able to answer any questions you have about our presentation, and then we'll go from there. So the first one is, do I need to apply for another LMIA before the expiry if the work permit is still valid? LMIA expires in July. Work permit expires in January. Employee has applied for PR status but has not yet received an invitation to apply. The position is service technician. Yeah, I mean, this is a bit of a loaded question, and there's a lot of information we don't have. So, I will do the best I can to answer the questions. My first question, though, is, was the LMIA, is it a new LMIA, or was it an LMIA that was used before? So, if it's an LMIA that was used for a previous work permit, like, you can't use it again. Like that's done. If it's a brand new LMIA that you just obtained, and you are looking to apply for, the individual needs to apply for a work permit so that their work permit doesn't expire, but their work permit doesn't expire till January, and you have this new LMIA but expires in July. I'd say go ahead and apply, get them to apply for the work permit with that LMIA, because once that LMIA expires, you cannot use it for a work permit. So, and work permits are taking, like, I don't know, 200 something days right now to process inland. So, yeah, tell them to go ahead and apply. If the LMIA, assuming the LMIA has never been used before for another work permit, tell them to go ahead and apply for that work permit.
Megan, they did answer and said it was used for work
Oh,
permit.
is it? It
Yeah.
was. It was used for work permit. Okay, so if it was used for a previous work permit, you cannot use it. You need to get a new LMIA. A new LMIA is required, to be able to extend that work permit. If the LMIA expires in July of 2025, that doesn't matter. If it was used for a work permit before, it cannot be used again. It can only be used once and for one employee. Question, is the Francophone path a path to PR? No. So the Francophone mobility work permit is a work permit. It's a temporary form work permit. It can be granted for a maximum of three years. It can be extended, but with if the individual speaks French, depending on what province they're in, there is almost certainly, and depending on their occupation and whether it's a low skilled or high skilled occupation, then there will likely be an option for them. But again, it will depend on their occupation and what province they're in and what provincial options may be available. There is a federal program, Express Entry, where the threshold to receive an invitation for French speaking individuals is quite low right now, but they have to be in a high skilled occupation in order to be eligible under Express Entry. They also have to have a CLB 7, so higher French in for the Francophone draw under Express Entry. So, that's kind of, again, a loaded question. We don't have all the information we need. If this person, I do recommend, if people are, looking at getting PR, that especially if they're French speaking, really good idea to have a consult, get some legal advice and understand what options are available, because there almost certainly is an option for PR if they speak French.
I will mention just briefly, Megan, there's that new pilot as well for French
Yeah.
communities. I guess that would only apply to certain areas. So like in Atlantic Canada, northern New Brunswick, the Acadian Peninsula, in Nova Scotia, it's like Collier. So it's typically like areas where there are French speaking people outside of Quebec. So that's also another interesting pathway that just opened.
Next question. Is it possible to disclose to IRCC ESDC minor changes to employment terms after employer is hired via voluntary disclosure? So yes, absolutely. There's a way to do a voluntary disclosure. However, before you do that, I would get legal advice, okay? Because it may not, everything can be can be okayed by a voluntary disclosure. When you do a voluntary disclosure, it's important that you provide information. One of the questions actually in the voluntary disclosure form is, what have you done to rectify the situation? And so, good idea to get legal advice as to, well, does it make sense to just get a new work permit and voluntarily disclose? Or is it egregious enough essentially that I need a new work permit? Or is it something that we can just rectify through a voluntary disclosure? It really depends on the circumstance. So highly recommend, before you submit any voluntary disclosure, that you get legal advice to ensure that you're not overexposing yourself, but also to make sure that you're doing it right, and that you're getting someone a proper new work permit if that's needed. Any other questions? It looks like we're good. All right. So we're pretty much out of time anyway. If any of you have questions or would like more information on training or legal services, feel free to reach out. We are more than happy to assist. And we look forward to hearing from you and thank you so much for your time.